Hey folks, today I want to talk to you a little bit about the time involved in criminal cases. I'm driving home tonight. Actually got out of the office first time in forever at 5:35, so I'm feeling pretty good. It's still, there's a little bit of light left. I got about 15 minutes till darkness, but what I wanted to talk to you folks about is criminal cases, misdemeanors, felonies, and the time it takes to come to a final disposition, basically for the court to end your case. Well, had a client recently, was charged with domestic violence, and the young lady was very upset, came to my office and was saying, hey, you know, how long is this going to take? And you know, I thought I had explained it at our first interview when she hired me, but apparently, you know, I probably didn't do the best communication. She obviously didn't understand, and she was back. It was only a week later, but I explained to her, I said, hey, listen, if your case is no filed, meaning the state declines to go forward on the charges, then they have usually up to about 40 days. Most times, as a defense attorney, we'll have an answer between 21 and 30 days. So I always say 30 days. And the reason I do that is because, respectfully, I don't want a client to call me on the 21st day, then on the 22nd day, kind of like a kid in the back seat going, are we there yet? Are we there yet? You know, I don't want to do that. I don't want to cause them stress, but I tell them, hey, you know, give me 30 days before I have an answer for you. So again, I thought I had conveyed this to the young lady, but apparently either I didn't say it properly or I miscommunicated or she didn't understand. Either way, no problem. You know, my job is to help people. So I explained it to her, but I just said to myself, you know what? I don't think I've done a video on this. I think it's important that people realize if the case is not filed, you'll have an answer 30 to 40 days, for sure, case gone. Now, can the state bring the case back? Yes, they can. Doesn't happen all the time, but it does happen, and there are just, you know, certain exceptions where that kind of situation could occur. Now, let's say, for instance, if they dump it, if they don't file it, they don't go forward, well, the case is over, and you're going to send me a Christmas card, and you're going to write a wonderful review and say I'm the greatest thing since sliced bread. Everyone who knows me knows that that's not the truth, but if they file the case, let's say they file the average misdemeanor, okay. The average misdemeanor, if I'm litigating it, meaning if I'm taking depositions, if I'm filing motions, if I'm considering a trial, my average case is probably a year to a year and a half, usually about 14 months. If it's a felony, you're in that same range, but maybe a little bit longer. Maybe you're looking at a year to a year and a half. I've had felony cases that have gone 2 and 3 years, but on average, you know, your third degree felony, your second degree felony, usually within a year and a half, we've moved forward and we've come to some conclusion. Well, obviously the goal is to hit a home run, right? Just knock it out of the park at case filing. Convince them that they don't have enough to go forward, that the likelihood of success on sustaining a conviction, of convicting my client, is so low that it's not even worth filing. That's what my goal is on every case. But sometimes clients come to me after the filing period. If you snooze, you lose, because we missed that opportunity. So when the case is filed, what happens? Well, it's a long process. First, I have to get all the discovery. Discovery is going to take 30 to 60 days. And on more serious cases, it takes much longer than that. When you're dealing with economic crimes, when you're dealing with trafficking cases, the reality is it just takes a while for the prosecutor to get all those documents. Yes, you can jump up and down and you can demand discovery pursuant to 3.220. You know, they have to give it to me in a certain amount of time. Look, you're not trying to piss off the people that are prosecuting you, right? You're trying to work with them. Now, sometimes you got to piss them off. That's the reality. But not over something like this. As long as my client is out of custody, hey, state attorney, Mr. or Mrs. State Attorney, take your time. As long as you need to get it to me, no problem. As long as you acknowledge that it's taken you some time to get it. So when the judge is jumping me saying, Mr. Foley, what's going on with the case? How come you're not moving it? Well, Judge, I'm still waiting on discovery. Isn't that so, Mrs. State Attorney, Mr. State Attorney? As long as we have that relationship and everybody respects one another, we're okay. If you're not in custody, the only thing you should be doing as my client is paying me and praying for me that I do the best job that I can do. And if you pay and pray, I'm confident I'm going to do the best job that I can do. So, and that's worked out for the last 11 years. That's my motto. But I understand if you're on the other side, if you're a defendant, if you're being charged with a crime, it's extremely emotional. I can only hold your hand so much, folks. My job is to look at all the legal aspects of the case, to go through the discovery, to take the depositions, to ask the questions, to do legal research, to file motions. But no matter what, I always tell people, take a deep breath and hang in there, because the process is the process. I can't speed it up. You know, I had a friend recently say to me, Mike D out in New York, said that my parents used to tell me, you know, Mike, you've been dealt a set of cards. You got to play the cards you got. And that's sort of, you know, I instantly align myself with that saying, because that's the kind of thing that I have to now deal with myself and share with my clients. We've been dealt a set of cards. You've been charged with a crime. There's discovery, there's a process, there's depositions, there's a process, there's ordering of CADs and 911 tapes, there's interviewing witnesses, there's all of these things, there's motions, there's trial. It's a process. And you have to coordinate. It's not just my office. If I could just say, hey, not guilty, not guilty, not guilty, and everybody paid and prayed for me, that'd be a pretty great job. But I got to coordinate with police officers, with witnesses, with court reporters, with process servers, with investigators, with my client, with the state attorney, with the judge, with the court's calendar. There's so many things. So you guys, you got to know, if you have a criminal case and it's being litigated, right? It hasn't been declined to case filing. You're looking at least a year. So take a deep breath. I always have my clients, we do a waiver of appearance, so my clients don't have to go to court. Now, you're more than welcome to go to court, and I tell all my clients, you're more than welcome to go. But every morning, I run in between 5 and 15 courtrooms per day. It means I'm working on 5 to 15 different cases. If it's set at 8:30, I may not be in that courtroom until 9:30, because I learned the system. I know what judges are there at exactly 8:30, and I know what judges take the bench at 9:15. And I know who's staying until 11:30, and I know who's out of there by 9:15 and moving on. Because I'm in the system every day. I know the players. So if you have a criminal case, folks, I know it's very difficult. Whoever you hire as your attorney, trust them, ask questions, keep in contact, but know that it's a long process, at least 1 year. I'm attorney Roger P. Foley. Thanks for listening. Take care.